Osborne Clarke is a law firm which is acting as well in Germany as in the United Kingdom, and we have the Osborne Clarke Alliance, which has several law firms in other countries in Europe, but we've also an office in the United States to advise clients in the US who wish to do business here and seek advice on European law. Co-determination rights of the Works Council also allow the company to find agreements on company level, to avoid discussing issues with every individual employee, but just discuss it with the Works Council. And if the company has a good relationship with the Works Council and can communicate quite freely, and they often obtain quite good solutions regarding the remuneration structure or regarding working times and so on. So it can be a tool to successfully use employment. At the moment we have the situation that the agreements, the collective agreements between trade unions and employers associations are already present in many sectors. So there are minimum wages to be observed, but it's not one national minimum wage. Yeah. Two minimum wages on a national level, or there will be one. We don't know this for sure now, it's just in the stage of discussion. The importance of collective agreements is quite high in Germany, which means that some part of the employees are bound by such employment contracts or collective agreements directly. Others have really negotiated terms and conditions of employment with their employers. General Equal Treatment Act, how we call it, from 2006, provides for anti-discrimination laws. However, the general idea is not new. It's not there only till 2006, because already before gender discrimination was forbidden, and other kinds of discrimination could have consequences for the people discriminating against someone else. So, nevertheless, this act has caused a certain number of rulings from the courts, which have clarified that certain behavior may give way to damages, and but in Germany the General Equal Treatment Act has not the same importance as anti-discrimination laws in other countries, because we have quite strict laws against unfair dismissal and so on, so that there's already a restriction, quite strict restriction on dismissals if a company employs more than 10 people. So this makes that it is not necessary for the employees to recur to discrimination. In Germany, it is not possible to just claim a severance payment. So people have to go before court and initiate a court procedure to obtain a settlement payment from their employer, unless such a payment is offered to them before and they agree to it. But usually there's a dismissal, and they are acting against the dismissal just to get a certain payment as a compensation for the loss of their employment. Since several years, Germany has reacted to the situation that we have not enough children being born in Germany in comparison to other countries, and they have initiated this act, which means that parents can take a leave of 12 months for one and 2 months for the other parent, which might be 7 and 7 also, but in a total it's not more than 14 months. And they're not paid by the employer during this period, but paid by the state up to an amount of 65% of their net income.